Okay, first of all, I would like to thank Xu and Dao for inviting me to give a lecture today. We can actually maybe more productive if we can just have a sit down and round table and talk about it. But anyway, so I am going to proceed with my lecture. So I'm asked to talk about Confucian tradition and the problem of rule of law. So in this lecture, I'm going to actually deconstruct the concept of rule of law so that we can better understand the importance or significance of Confucian tradition in understanding the problem we encounter today in China with the judicial reform. Okay. So here you can see 5 passages. Each one touch upon an issue, and each of these will be discussed in the lecture. Okay. So first of all, rule of law is a liberal view of governance. It's not just about law, it's a theory of governance. Scholar Tom Bingham defined rule of law as all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefits of laws publicly and practically promulgated by the courts. Okay. So based on this definition, there are 6 key components of rule of law. The first one is universal applicability and accessibility to all citizens. The second one is universal applicability and accessibility to officials. And then the third is political system. Fourth, public promulgation, and then it has to be written, and then a system of courts. So these are 6 components of rule of law. Both law and rule of law are Eurocentric theories. So law in China is basically an import from the West. And Chinese legal tradition in general had been influenced by Confucianism. As a result of that, a paradigm has developed pitching rule of virtue, dezhi, against rule of law, fazhi. Okay. So I'm going to examine this problem from 4 perspectives. The first one is the history of discourse on law and rule of law in Europe. Second, theoretical approaches to law. The third, cross-cultural translation. And then fourth, I look at the Confucian discourse on fa and the importance of law-abiding tradition in Confucian ideas. And then I want to highlight 3 misconceptions. The first one is that law is autonomous. Second is the law is independent of morality, which is erroneous. The last one is that rule of law, the relationship between rule of law and good governance. Okay, so I'm going to divide my talk into 4 parts. The first part, the history of law and rule of law in Europe. Second, the decline of the autonomy of the law and challenges to the liberal view of the rule of law. The third is the problems involved in cross-cultural translation. and the Confucian view of law, or fa, Confucian view of fa. The fourth part, I will talk about the problem of building rule of law, 法治建设 in China today. Okay. So in the first part, I'm going to talk about Greek work of normal, Plato and Aristotle's ideas, and then the major ideas of liberalism, and then John Locke's theory of the rule of law. The current concept of rule of law is a projection back into history. It's a backward projection. Okay? When Constantine Fazot write about the contribution of Hermann Koning, who is a European scholar of legal history of Europe, he distinguished two senses of history of the law. The first one is history of law, the second is legal history. Okay. The difference is one concerns the history of the law as it happened. The other, concerns the knowledge people have of those changes. So one is what just happened. Okay. The other one is what people talk about, what people know about what changed. Okay. But I find these two terms very confusing, so I use different phrases for them. So I will call history of legal practice, that is law that happened, as practical history of law, and the history of legal discourse, that is history of law as we know it, the knowledge of law. So it's discursive history of law. And what we are familiar with, and what I'm going to talk about, is the rule of law as discourse. Okay. So I'm going to talk about how this rule of law as a discourse, the genealogy of discourse, was constructed. If you look at the Stanford Encyclopedia of Philosophy on the rule of law, the rule of law has been an important ideal in our political tradition for millennia. Okay? And it is impossible to grasp and evaluate modern understandings of it without fathoming that historical heritage. Now, so the author of this piece traced this rule of law back to the ancient Greeks, right, for millennia. This is definitely not true. Okay. I'm going to deconstruct that genealogy. And Plato has written a text called the Law in English, but in Greek it's normal. Normal actually means law as we understand it today, like the law instituted by the government, written law, but it also includes non-written, like what we call customs. Okay, so the Greek word normal actually means law and custom. By translating normal just as law, that translation narrow the scope of the Greek work into just law and exclude custom. So in the Greek work normal, it includes both grava normoi, that's written law, and the aggrava normia, unwritten, so both written and unwritten. And for the unwritten, it is also called patrio normos, that is the laws of the ancestors, just like Chinese 祖宗法, custom, ritual, music. So if you look at the Greek word normal, it's very comparable to the Confucian fa. Okay. Now, Europeans like to trace a lot of ideas back to the Greek, okay, including like the idea of democracy. But if you look at Plato, for Plato, democracy is not the best form of government, okay? Because for him, democratic life has neither law nor order. Why? Because the citizens had an unquenchable desire for limitless liberty. Okay, as we can see in today's democracies across the world. And citizens of a democracy chafe impatiently at the least touch of authority, and at length they cease to care even for the laws, okay, written or unwritten. They will have no one over them. And also for Plato, the democracy also is the spring, is a system that actually produces tyrants. Okay, this and no other is the root from which a tyrant springs. Okay? And he called this the people a mob entirely at his disposal, at the disposal of the tyrant. Okay. Now, theories or the liberal thinkers of the rule of law often trace the idea of rule of law to Aristotle. Okay. But as I pointed out earlier, the Greek word normal, okay, means more than just law. So if you translate rule of normals as just rule of law, you misconstrued the meaning. Okay, you distorted the meaning. Okay, so when Aristotle said no rule is above the law, actually he was talking about normal. Okay, and the rule of law, he's talking about the rule of normals. Okay, is preferable to that of an individual. He's not talking about what majority of the scholars are referring to, that is the rule of law as instituted by the government. Right? So rule of law actually means rule of normals, both written law and unwritten law, both the grava and the aggrava, and also the patrio normals. Right? So both government institute law and communal norms of Athens are what Aristotle called law. So the rule of law means the rule of law, written law, and the norms. Right? Now, as I said, I mean, it's a mistake to trace this history of rule of law back to the Greeks, because according to the modern concept of rule of law, there is this very important concept of equality in law, right? Equality before law. Okay? But if you look at Aristotle, he tried to justify slavery. So if you just try to justify slavery, so that means not everyone is equal, right? Because the slaves obviously are not equals of the citizens. Okay, and of course, Aristotle also thinks that women are not like the equals of men. So if you look at Aristotle's idea, there is an absence of a modern idea of civil equality and what has been called universal human rights. If you agree with universal human rights, you have to oppose slavery. Okay, now let's look at John Locke. So John Locke actually is the key figure in formulating this theory of rule of law, and he is almost like the father of classical liberalism. But before we can really understand John Locke's idea, we have to go back to the 17th century and examine the political and religious context of his ideas. So in the 17th century, actually, there was ferocious struggle between the English monarch, the king, and the aristocracy, who control the parliament. So between 1642 and 1680s, there was a series of battles and war, which have been called the English Revolution or Civil War. And the major point of conflict is the king's authority, the king's power over the government. And the aristocracy were trying to resist the king's power using the parliament, through the parliament. Sir Robert Filmer, he was a pro-monarch aristocrat. He defended divine right of kings, so the kings have divine right to rule. So in 1680, he published this text defending the king's divine right to rule. Those who oppose him, the aristocrats, right? Adjoron Sidney published a text refuting this idea of divine right of kings, but he was executed. A friend of John Locke, James Terrell, he published another text disputing the idea of divine right of kings, but the Patriarcha non Monarcha in 1681. Now he published this anonymously, so nobody know who wrote it, but he published it. Okay, and he was a good friend of John Locke. Okay, so John Locke, of course, was very, very important. He sided with the aristocrats, and in this text, the second treatise of government, which have been actually upheld as like the Bible of the liberal, classical liberalism. Okay, he put forth a number of key concepts, which scholars or thinkers turn to in their construction of a modern view of rule of law. So in this second treatise of government, he refers to the state of nature. Okay, so in the state of nature, so people were given natural rights. Okay, so the rights were given to them, okay, by nature. When they were born, they were given these rights. Okay, but in fact, who created nature? Because John Locke was still a Christian, so he still believed in God. So it's God who created nature, and God also created a principle, a law that governed that nature, right? So that so-called natural law actually is grounded in the Christian idea, in the Christian religion. Okay? So Christianity is a very important part of classical liberalism, but a lot of people, they don't talk about this, okay, as if it was a secular idea of rule of law. Okay? But that is a mistake. So as you can see in this statement, he said the state of law has a law of nature to govern it, right, which obliges everyone, and reason which is that law teaches all mankind who will but consult it, right? That being all equal and independent, no one ought to harm another in his life. Okay. Now he's basically talking about as a member of the aristocracy. And sharing all in one community of nature, there cannot be supposed any subordination among us that may authorize us to destroy one another as if we were made for one another's uses, as the inferior ranks of creatures for ours. Now, the struggle between the king and the monarch on the aristocrats actually was over what? Wealth, of course, is always struggle over economic resources. Okay, so economic resources in terms of what? Property rights, the right to own property, the right to maintain one's property. Okay, so that's why this struggle was phrased in those terms as the freedom, the liberty of ownership. Okay, so that's why we cannot just look at this European idea of rule of law and then treat it like a universal truth. We have to put it back in history. Now, there's actually a very important part of John Locke's idea of rule of law that has not been talked about, and that is the importance of education. And morality is the basis of rule of law. Okay. So Locke said, I think I may say that all of the men we met with, 9 parts out of 10 are what they are, good or evil, by their education. So it is through education that people become a good citizen or a reasonable citizen, a citizen who can be independent. Right? So this is very important for any citizen in a society, okay, governed by rule of law. Right? Without that, there will be no rule of law because you don't have that education. You don't have, so the members of the society will not be able to follow the law and observe the law. if you look at Locke's idea of education, which he expressed in a separate text, in a separate treatise, it's called Thoughts Concerning Education. So it's not in the second treatise of government. It's in the Thoughts Concerning Education. If you look at that text, and you can see that he had anxieties about the attributes of the mind, that the mind has these compassions, right? People have to be able to learn to control their selfish ideas. So it is very important to teach children morality, teach morality and reason to children. And they have to be done early on when the individuals are still a child, right? So that's why to get a mastery over his inclinations and submit his appetite to reason. And that process needs to be done very, very early by cultivating habits. So that's why he said, repeating the same action till it be grown habitual in them, and hence the performance will not depend on memory or reflection. It becomes part of them, right? Automatically you will do that. Just like when you walk to the signal light, right? The traffic light, you will stop there. By habit, you have to wait until the green light turn on, then you go. Okay. Now, so this continue to talk about how his ideas of the political ideas, as rule of law, are connected to his ideas of education and virtue, moral education and virtue. So this is what he said, the great business of all is virtue and wisdom. So virtue is something you acquire, and that becomes part of your personality. It's not something you think and then you, the ability to make the decision between right and wrong. Okay? So make his mind as sensible of credit and shame. So he talked about shame as well. And when you have done that, you have put a principle into him, which will influence his actions when you are not, by to which the fear of a little smart of a rod is not comparable. So a rod means you punish a person, right, in order to get the person obey and follow, right? So the true principles of morality and religion. So in John Locke's ideas of rule of law, there is assumptions, some premises of that the person have to learn the morality and also the religious virtues, okay, as the foundation of rule of law. So a contemporary scholar, Uday Mehta, has made observations between the idea of rule of law and education. So he said the tripartite relationship between the exercise of parental authority, the inculcation of reason and judgment in the child, and the realization of the capacity for self-restraint, again in the child. Thus the crucial capacity for reason, which is the basis for being free and for abiding by the laws of nature, and which in the second treatise is presented as a natural capacity. Okay, in the second treatise it was presented as a natural capacity, but it's not. Right? In the Thoughts Concerning Education, it was a result of education. Right? Itself requires parental molding of the will, which in turn requires the experience of the early submission to parental authority. Right? The training of children from very early on is very important. So the second part, I'm going to talk about the decline of the autonomy of law, challenges to a liberal view of rule of law. This view of the standard view of law is the liberal view of law, okay, and it is and has been and it still is the dominant view, especially among practicing lawyers and jurists, okay. But increasingly, there have been challenges to this view or criticism of this view. Okay, primarily focusing on three issues. We'll focus on three issues. One is the autonomy, the claim of autonomy and determinants of the law. The law is autonomous, okay? And the second is equality before law. And then the third is universal applicability of the liberal model of law. Okay. So first of all, in a field called critical legal studies, scholars who criticize the liberal view have been referred to as legal realism. What that actually, that kind of a school of scholars argue that law is not independent of social relations. It is part of power relations of society. So that's why this is critical legal studies, trying to show power relations and social disparities are part of that shape, actual factors in shaping the legal practices. So law does not transcend power, and law does not maintain its neutral position. And then in political science, there's a group of scholars who adopt a called attitudinal model. This group of political scientists, they study the behavior of judges. They study how they actually make decisions, okay? And their conclusion, of course, also challenge the liberal view of rule of law. That is, that the judges also do not adjudicate, do not make the decision independent of power relation and social disparities. And then even within the practicing lawyers and jurists, there emerged a school called legal pragmatism, championed by Richard Posner. Richard Posner is a federal judge in the US, in the United States. As early as 1993, he published a book called How Judges Think. Okay. And then recently, 2013, with, in collaboration with other scholars, he published a study of the behavior of federal judges. Okay. He studied how the US federal judges make the decisions. Right? It is called a theoretical and empirical study of rational choice. And then, of course, his conclusion is, his finding is that the judges do not transcend power relations. In fact, the judges actually make decisions based on considerations of their own personal interests, okay, including career and economic interests. Okay, now even though the majority of the American scholars, American lawyers and jurists, they refuse to accept this study, right? Like Lawrence Solon, he of course criticized Posner and his colleagues, but he had to concede that Posner's study and the others challenges from like political science and the critical legal studies have put holes in the wall that the liberal thinkers of the rule of law have put up. Right? So in other words, he had conceded that this criticism actually had done damages to the idea that the law transcended power relations. Now, another challenges came from very influential thinkers, Michel Foucault. I think you have heard of Foucault, and Pierre Bourdieu. So I'm going to just focus on these two persons. The study of Michel Foucault and Pierre Bourdieu pose indirect challenges to liberal jurisprudence. So they did not really challenge them directly, but in their study, they challenged this liberal idea of law as independent and transcending power relations. Now Foucault differentiates between two types of power. the juridical power and the legal power. The legal power is just like the power that we see in institution, right? The law instituted by the government. That's the legal power. But there are power that is not legal, but is still power. Right? The power of the parents, the power of the religious, the church, right? The power of custom, society. Right? So these also are important forms of power, which are not legal, but they are. So this is what Foucault called juridical. Right? So he makes the decision between the two. Like, so the mechanism of law, taboo and censorship. Right? So this form is the law of transgression and punishment with its interplay of licit and illicit. Whether one attributes to it the form of the prince who formulates rights, of the father who forbids, and of the censor who enforces silence, or of the master who states the law. In any case, one schematized power in a juridical form. Okay. It is a power whose model is essentially juridical, centered upon nothing more than the statement of the law and the operation of taboos. All the modes of domination, submission, and subjugation are ultimately reduced to an effect of obedience. Okay. So, Victor Tatros, he pointed out that the Foucauldian account of the relationship between law and power provides a fundamental challenge to liberal jurisprudence. Okay. So that's why Michel Foucault does not challenge directly this liberal view of law, but it fundamental challenge and indirect challenge to it. Now, why Foucault underscored the importance of power, the different forms of power, the power beyond the law, okay. But he does not really try to account for how law will reproduce and have the effect of why people think that law is neutral, why people think that law is autonomous. Right? And Bourdieu, he is a sociologist, so he tried to explain why people think about why they have this kind of impression, what kind of strategies that the lawyers employed to produce that kind of effect. So that's why sociological theory of law of Pierre Bourdieu help us understand this. So we can we can modify Bourdieu's theory of juridical field, and we can, with that kind of analysis, we can deconstruct the legalist claim of autonomy and neutrality. Okay, how? By analyzing the rhetorical devices in interpreting and writing proceedings of legal professionals. Okay, and also analyzing the critical connection between legal rhetoric and the monopoly of defining and administering justice by lawyers and jurists. Okay, so as a result of this analysis, we can unravel the myth that legal profession and the judiciary are arbiters that is above inferences, power and relation and inferences. Okay. All right. So Bourdieu differentiates two approaches to the law. One is his own, that is a sociological approach, which he believed to be a vigorous science to the law. The second is jurisprudence. And within this, there are two camps. One is the legal formalist, the other is instrumentalist. The legal formalists are those who believe in the neutrality of law. The instrumentalists are those who believe that law is an extension of power. Right? Okay. Now, so what is a juridical field? According to Bourdieu, it is a social universe in which law is produced and in which it exercises its power. Okay. Now, so in this case, he defines the juridical field in terms of exclusively legal, only those laws promulgated by the government, right? So this is a much narrower definition than the one provided by Foucault, right? Because for Foucault, the juridical include both law and those beyond the law. And for Bourdieu, the juridical only refers to the law. So that's why I said I combine the two and I modify his concept and expanded the scope to be like the Foucault's juridical, but then incorporating Bourdieu's idea of field, the juridical field. Okay. Because Bourdieu is a sociologist, he's trying to study the internal logic of juridical functioning, as well as how that was reproduced. Okay, why this was able to reproduce as a social system. So Bourdieu offers a profound analysis showing how and why we get this impression that law is autonomous, law is neutral, lawyer is objective and neutral, they just follow the law, okay. But in fact, according to Bourdieu's analysis, it is the procedures and skills of reading and writing text, all these skills and proceedings that the lawyers learn that produce effects, okay, neutralization effects and the universalization effects. So these effects are produced by a set of synthetic traits such as the predominance of passive voice, right? Impersonal construction, so as if it transcends individuals. Right? It created by a group of convergent procedures, systematic recourse to the indicative mood. So use the grammatical, rhetorical phrases such as accepts, admits, commits himself. So as if they are not involved, as they are just stating the fact, right? So these rhetorical devices produce the effect, okay, and that gives people the impression that the lawyers actually and the judges, they are very objective. They just adjudicate according to the law, right? Okay. But in fact, the so-called rules and procedures that they follow give them a lot of flexibility in interpreting the law without undermining the claim of neutrality, okay? Such as restrictio or extensio, okay? Restrictio is a rule that you follow in interpreting the text, right? So restrictio means, okay, you have to restrict the meaning. So you have many meanings, right? But then you exclude the other meanings, you choose to focus on this. So and then you claim that you are applying that restrictio principle. But then you can also apply the principle of extensio. When you find not sufficient, the scope of the law is too narrow, you expand in it, okay? So it seems like they are following these two principles, but these two principles actually allow them a lot of flexibility, right, in interpreting the law. Okay? And they claim to monopolize the authority of interpretation, right? Even today. Why do we have to hire a lawyer? Because only they know the law, and they can interpret the law. Okay, you cannot read the law. You don't understand the law because you need to have special training to understand the law. Okay. Now, so for Bourdieu, the juridical field is the site of a competition for monopoly over the right to determine the law. But it's only those agents in the field, that is the lawyers, the judges, not us. We are excluded from the field. Okay, so this is how it works. Okay, now I'm moving on to the third part. I think I have a lot of time. Okay, so through translation, a lot of meanings are distorted and lost. Okay, so how the Confucian view of fa, the Chinese word fa, has been misinterpreted. First of all, okay, law, as we understand it today, is a European enterprise. Okay. And Kenneth Nunn, himself a lawyer, a scholar, he said, Eurocentric enterprise, so law is a Eurocentric enterprise, which carries out a Eurocentric program as it organizes and directs culture. Law does this by reinforcing a Eurocentric way of thinking, promoting Eurocentric values, and affirming, indeed, celebrating the Eurocentric cultural experience. A conceptual system of worldview that is grounded in materialism and that exhibits an epistemology, aesthetics, and ethos based in material values. So this idea of law, okay, this law primarily comes from European experience, historical experience. But since the late Qing, we have been told and taught that the Chinese law, okay, is, so in Chinese society and history, law was not important. So there is this Orientalist view of law in Chinese history and culture, which is that law was not important in Chinese government. And why? Because of the Confucian approach to government. Because the Confucian only talk about the virtue, right? And li, right? And li, of course, they translate it as a ritual. Right? So that's why Confucian approach to government, Confucian approach to order is rule by people, 人治,不是法治. And Chow, right, is the one who actually popularized this idea that Confucian's approach to government is ruled by people, 人治主义. And the legalist, right, 法家, 法治主义. Okay. Now, so he actually internalized what the Europeans have said about Chinese law. Okay, now, so what is rule of law as today, how we understand it? Even the American lawyers do not know what exactly is rule of law because there is no one single definition that everyone agrees upon. So that's why this is from the American Bar Association. It said the rule of law is a term that is often used but difficult to define. But everybody uses it, even though it's difficult to define. Okay. The problem of translating rule of law. So that's why when we talk about rule of law in Chinese, it's very confusing. So I'm going to differentiate three senses of rule of law. The first one is what I call structural rule of law. In Chinese, 政体法治. It's about the structure of the government. Okay. Second sense is administrative rule of law, and that actually is 市政. 市政法治 means governance. Okay, so when you you carry out policies, enforce policies, whether you are doing it according to the rules, according to the law. The third one is judicial rule of law. That is, when you abdicate, right? When you have dispute, when you have you want to settle the disputes, are you following the rules set out by the government? Right? So I call this judicial justice, judicial rule of law, 司法法治. Okay, so three of them are not the same. So it's very important to differentiate the three. And three of these also correspond to three types of rationality of justice. 公义理性. The first one, juridical justice, I call it 理法公义 or social justice. 理法公义, the whole society, the justice according to the whole society. And then the second one is administrative justice. Okay, whether, say for instance, the one-child policy, whether it's a policy that the government should adopt, right? You know, one-child policy, right? Then the third one is judicial justice. Whether the process, the procedures of trial, court system, okay, whether they are rational. Okay, so there are three different types of justice corresponding to three different sense of rule of law. Now, do the Confucian only talk about virtue when they think about government, when they think about governance? Right? So let's look at the text in the ancient period. Right? Fa, the word fa, okay, is polysemic. Polysemic means has many different meanings. Right? Most words have different or more than one meaning. Okay. So if you look at the Senqin text, there are different words that refers to regulations, okay, like fazhi, government institutions, or fadu. So these are all terms that refer to government regulations or institutions. And then there's faling, right? There's orders, government orders, okay. Fazhi, so those are penal rules. If you do this, you will be punished. You murder someone, you will be punished. You steal something, you will be punished. So this is penal law, right? Right. So, and then if you look at the Shangshu, look at Zhou Li, you will also find other terms that refer to penal rules or the faling, right, or government orders or fazhi regulations, such as dian and xing. So dian and xing also are terms that in many ways are synonyms of fa. Okay, fa, okay, can be dian, right? And it can be xing, right? So it's not just xing, it's the only term for penal law, right? Okay, if you look at this Piqin, 周文王之法, right? So, and then 征伐度, right? And if you look at 州官, 州理, 天官, 大法之官府. So these fa, of course, government regulations, right? 鼎贤, right? The 吃经, 上有典刑, right? So referring to government regulations and also punishment, right? And then the 诗经文王之典, right? Also refer to the regulations. 一诗行文皇之典, okay, yeah, same thing. So for those who know the 明清清会典, 大明会典, also called 典, 唐六典, right? So 典 also refers to law and regulations. So it's not just fa. Fa also can mean many different things. So if you look at 周礼, supposed to be Li, right? But Li actually will also overlap with Fa in terms of its meaning, right? Semantic scopes. Fa and Li overlap. So Fa is Li, Li is Fa, right? In many specific categories. So that's a 以法讲句式, right? So 侨进会同宾客. So these can be considered as Li, right? But they are Fa. Right? 军旅, right? The military. So these are, of course, institutions. So if you look at, so that's why it's fallacious, it's erroneous to dichotomize Fa and Li. That is, the Confucian only talk about Li, not Fa, right? Of course, Confucian talk about Fa. Fa is very important. But Fa is not the only term that is used to refer to government regulations. Right? So that's why when Confucius said in Wei Zheng, right, 道之以政, 其之以刑. Zheng already include government institution and also include government regulations as well as punishment. Right? But particularly, of course, he's separate because he wants to emphasize that you cannot just use force to force people to secure obedience. So that's why 道济德, you have to train the people, educate the people, and you have to be a model of virtue. 齐己, okay, and then 由此且得, right? So, but often this passage have been used to criticize the Confucian for not using law, especially the xing, right? But that's a mistake. Now, Confucius actually, every individual has different habits of using in their language, right? Confucius like to use zheng or li. He does not like to use fa, okay? But does that mean he doesn't think that fa is important? Fa in the sense of punishment, in the sense of government regulation? Of course not, right? He likes to use the word li, so that's why he said 殷殷于下礼, right? 所选, he likes to use this 礼 to refer to 制度, right? Institutions. Now, one time, Zhilu asked him, right, what about government? Right? 为政 is about government. And Confucius, be a 证明符, who, right? So you have to ratify names, right? And then Zhilu said, you are so pedantic. Right? And then the Confucius scolded him. Because 证明 is not just about the names, because without these proper names, you will not follow, you will not behave accordingly. Without that, 刑罚不重, right? 刑罚不重, 民不无可, 无所处手足, right? So, 礼乐不兴, 礼乐不兴, 这刑罚不重. So, the punishment and the law and the ritual and music, okay, all this education, they're connected. They're not separate. So that's why if you criticize Confucius for not paying attention, not considering punishment as important, how can you explain this? Right? Clearly, Confucius, of course, thinks that it's important. Punishment is a part of government. It's an important tool of government. But he does not think that a government should just depend exclusively on punishment. Right? And then look at Mencius. Okay? And often people cite Mencius. Maybe I talk too much. Okay, need to talk faster. Move faster. Okay, so Mencius have been criticized for this. 陶氏不足以为政, 土法. So again, he was criticized for not paying attention to 法, understood as like the modern notion of 法, law. But it's not true, because if you look at Mencius, 法 means more than just government regulations and punishment. Okay, 遵宪皇之法, it means 制度, including punishment. And then it's very important for 君子刑法. A 君子 have to what? Follow the law, practice the law. Law in the sense of law and norms. Okay, the 礼法, not just the government rules. Okay, now this is very interesting. So Tao Ying, this is really significant. This is a story Mencius created to highlight the conflict between law, okay, the government law, and a personal responsibility. So the story is Sun wei tianzi, right? Sun was the emperor, or the son of heaven. Son of heaven. And Gao Tao, he was like the prosecutor, right? The official responsible for law enforcement. Okay. And Gu Shou was the father of Sun. And Gu Shou killed a person. Okay. So this Tao Ying asked Mencius, what should Sun do? What should these Tianzi do? Right? Mencius, of course, what can he do? Of course, this Gao Tao, this official, have to arrest him, arrest the father of Sun, right? And then Tao Ying asked Mencius. So the son of heaven, Sun, did not prevent this official from arresting his own father. And then Mencius said, of course not. Why? Because he was appointed to do that job. that is to arrest people who committed the murder, right? And then what should Sun do, right? Sun was the son of heaven, right? What should Sun do? Okay, Sun, because he did not consider the Tianxia was a big deal, right? So he just ran away with his father. So that, of course, this is highlight the conflict between a personal duty toward his father and his moral duty of observing the law, right? So it's very clear that no one is above the law, according to Mencius. Even the emperor, even the son of heaven, Sun, is not above the law, okay? And the official, judicial official, Gao Tao, he had to perform his duty, okay? So this is a Confucian concept of rule of law, that is follow the government instructions, follow the government regulations. It is what I call the administrative rule of law, okay? And also judicial rule of law. Remember the three senses that I distinguish: structural sense, structural rule of law, judicial rule of law, administrative rule of law. So the Confucian idea of rule of law include these two senses. Okay, and Xunzi, of course, also the same. Okay, I'm going to, in fact, Li and Fa, even more the same. So as you can see that the Fazhi came from, Fazhi is Han Fei, right? Han Fei was a student of Xunzi. So the logic is clear. So I'm going to go faster. Okay, so let's kind of summarize before we move on to the last section. And that is for the Confucian, okay, observance of law, shoufa, okay, is a moral duty for Confucians. So don't think that the Confucians don't care about law. Okay, that's not true. Confucian terms of fa and li overlaps in meaning. Okay, therefore fa is highly comparable with the Greek normals. Okay, meaning both government institute written law and unwritten rules based on normative and communal norms. And then for the Confucian, also no one is above fa. Okay. And also for Aristotle, no one is above the norms. Observance of law is the virtue, okay, and duty of all, including officials and rulers. Okay. There's some garbage up in there. Fa and norms are based on communal norms. As a contemporary scholar, a very influential scholar, Alastair McIntyre, he said, morality, which is now particular society's morality, is to be found nowhere. So whenever you have a society, you will have morality. Okay. For Confucian, as much as for Aristotle and Locke, ethics and law are inseparable. So you cannot think of law independently of ethics, independently of power, independently of society. So Aristotle, if you look at Aristotle's Nicodemean ethics, he said, lawgivers make the citizen good by inculcating good habits in them. Okay, you cannot have a law-abiding citizenship without morally trained citizens. If the citizens are not moral, they will not be law-abiding. The comprehension of normative meaning over literal reading of the law. This is a point I make under Xunzi. So the last part, okay. The problem of building rule of law in China today. Right? So legal reform had been part of the reform program the Communist Chinese government had been undertaken since the late 70s. Right? But since 1988, there have been already at least 4-5 year plan of legal reform. So according to some scholars, there have been good progress between 2003 and 2014. But after 2014, it ran against a war. Okay. So according to Li Lin, there have been mixed assessment of the legal reforms. So one good progress. Of course, this represents the government's position. Others represent more critical of the government, a reversal of progress, even worse than before reform began. Okay. And then the third, recent years judicial reform backlash and return to the rule of man, 人治. Okay. So this is the kind of pattern that people keep going back to. And then legal reform, the fourth one is legal reform is at a crossroad, so people do not know what to do, which direction in which China should go. Right? And the general problems, there are a number of general problems that scholars identify, but I consider these are 施政法治问题, right? Administrative rule of law. Okay. It's not the structural rule of law problem, such as strict in legislating, pervasive violation of law, selective enforcement of law. Right? So these are the problems. So back as early as 2012, Xi Jinping already pointed out that the Chinese government need to have more oversight mechanism, and also there was a deficient design in the judiciary and the constitution. There was a widespread or pervasive violation of law, selective and selective enforcement of the law, abuse of official power. So all these problems have been identified and recognized. And further, last year, Xi Jinping emphasized this 依法治国, right? Govern the country by law. But it's not the European, the liberal view of rule of law. Okay? Govern the country by law, 依法治国. So 依法治国, of course, refers to what I call the administrative rule of law and the judicial rule of law. Okay, so Xi Jinping proclaimed this goal, build a socialist country of rule of law with Chinese characteristics. Okay, 中国特色社会主义法治系体系. Of course, this is part of the goal of building a 小康社会 in 2020. So the reform that have been proposed focus on 4 areas. The first one is 司法独立, independence of judiciary. Okay. And a national supervision commission have been created to supervise, to oversee the judiciary. Okay. And then the next area is elimination interference by local government. Okay. 去地方化, right? Because the local government interfere in the judicial system, in the court trials. And then the third one is the transparency of judicial rulings. So make the judicial process transparent so that people can see and they can oversee. And then the fourth one is the professionalization of lawyers, to provide more professional training of lawyers and jurists. In fact, they have been doing that since 2011. Now, this National Supervision Commission is very important because it is designed to supervise not just the judiciary system and the government, but also the party. The commission have authority over and duty oversee officials in the government, the jurists, judges in the court system, and also members of the Communist Party. So to conclude, from what I said, okay, there's a deficiency in the judicial and institutional reform in China. Okay. Now, Xi Jinping himself have recognized this. He said, the sense of the constitution of the citizens, including comments in leadership position, need to be heightened. 公民包括一些领导干部的宪法意识还有待进一步提高. What does that mean? It means people did not have this commitment, did not have this sense. Right? So, how do you address this? Current, as far as I know, okay, the current reform do not really focus on this. Okay, so that means education and cultivation of virtue of observance of law. is the key. You need to do that. You need to educate the people to have a sense of law observance, shoufa, right? From very early on, just like what I have talked about. Since childhood, you have to train and learn to follow the rules, obey the law, right? Shoufa, right? As a virtue. And observance of law has been a virtue central to Confucianism. Those people who argue that Confucianism doesn't respect law, that is totally inaccurate. Okay. System reform needs reform of moral psychology. Doesn't matter how many laws you put up. Doesn't matter how many commission, 这个监测委员会. People are not going to follow the rule if they know that they can get away from it. So you need to allow people to internalize these values. So that's why when Confucius said, if people be led by law and they be kept in line with punishment, people will try to avoid punishment and will have no sense of shame. If they be led by virtue and kept in line with virtues of propriety, they will have a sense of shame and will become good. 道之以政，齐之以刑，民免而无耻。道之以德，齐之以礼，由此切割. So Confucianism has a rich cultural tradition for building a better Chinese society, has a lot to offer. So this is an art show by Zhang Huan, 2011 in Shanghai. So the theme of this is what is the role of Confucius in this crossroad of China? Right? Is Confucianism going to offer big contribution, or Confucianism is simply an obstacle, not making any contribution to China? Okay, thank you.